I advise my lord. My lords, I understand normally in the theatre the showstopper comes before the intermission. But I will be a little bit different and give the showstopper right after the intermission, which is the Asset Recovery Agency case, which is at page 694. Because this is the case which was crucial in the Court of Appeal's determination not to permit the background evidence. And I see that my Lord Hodge was sat on that case. It is about customer information orders on the POCA, but it is of equal application because it deals with the access conditions and the interplay of the 30th of May 2007 to investigative orders. And so I think it's of equal application to search warrants. And I pick it up at page 705 of the electronic, which is paragraph 21. So at paragraph 21, under the rubric scrutiny of applications, I believe it's Lord Hughes who wrote this judgment. He says, 4 lines down, the role of judge is crucial. The duty of the applicant to the court is of great importance. Application of this kind will normally be made ex parte. All ex parte applications impose on the applicant duty to disclose to the judge everything which might point against the grant of the order, as well as everything which is said to point towards the grant. That's the duty of candor being set out there, paragraph 21. And he says that towards the end of paragraph 21, the role of the judge is to ensure that the order is justified. And in the context of a CIO, that means, and he lists A, B, C, D, and he notes at D, testing whether the condition is met, namely that there is reasonable grounds for believing that it is in the public interest for the information sought to be ordered to be provided. This is the public interest test, which also applies in search warrants. Indeed, more so because a search warrant is a most serious imposition into our privacy. And he says, this means performing a balance between the public interest in detecting money launderings and the legitimate interests of individuals whose affairs are in question to preserve the privacy of those affairs. At paragraph 22, as the Court of Appeal rightly held, the appellant application and its affidavit evidence in support were deeply flawed. Amongst the principal defects were the following. Now, I would like your Lordship to pay particular attention to the defect at Roman numeral 4, because I believe that is crucial to this case. The assertions of suspected criminal behavior were made, included much which was said to have taken place before 30th of May 2007, and thus which could not have been criminal conduct and could not have generated criminal property for the purposes of POCA. So in Asset Recovery Agency, the board was clearly saying that pre-POCA conduct falls outside of the POCA investigative orders. And I would think the reasons for it are clear. The first reason is that you need to prove an investigation on the POCA. And the second reason being the first one that I made, that indeed, for it to be firmly grounded within POCA, it must be evidence which is immediately admissible under a potential POCA trial, and not evidence which may be admissible to prove what would otherwise be incomprehensible. So if it is that the MOCA in this case, MOCA and Asset Recovery Agencies are sister agencies. If MOCA had followed what my Lord Hughes had said here, we would not be in the problem that we are in today. They needed to differentiate clearly in their application what was pre-POCA, post-POCA. And I am reminded to say to the board that Jamaica's constitution has a particular provision prohibiting retroactive penal statutes. So that that is the reason why POCA has that 30th of May 2007 saying you cannot have criminal conduct before. That section of the Constitution, I just say it to my lords so that in case your lords are, is that 1710? 1710, I believe, is that provision which prevents, 1610, I'm sorry, prevents penal litigation. So so what we have then in this case is there's an assumption in the Court of Appeal judgment that, oh yes, this could have been, in any event, Money Laundering Act offenses. But it's too easy an argument to make because, again, the state would have to show that the predicate and the laundering took place before 30th of May 2007. They have not done so. So we are left with a situation where we cannot say when the offending took place. And at paragraph 26 of my written submission, I make the point that that what the appellant ought to have done is clearly set out the relevant dates of the transactions in the application for the warrant. Those need to be clearly set out. It was of greater value to specify the date of acquisition before the warrant judge than it is now before the board. Further, a lot was said about the Interpretation Act, Section 25(2). I could take you to it. It's at 632 of the digital bundle. It's the familiar provision where an act repeals any other enactment, then unless the contrary intention appears, the repeal shall not, and it...
Sorry, could you give me the page number?
I'm sorry, my lord. 632 on the electronic.
632, thank you so much. Oh yes, section 25.
632, so 2C, for example, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. So what that would mean is, if under the Money Laundering Act regime, the money laundering offense was complete, that is both sides of it complete, you could prosecute somebody for that, of course, even though the act is now repealed. But you cannot use it to say, after the Money Laundering Act is repealed, you have now dealt with property which was criminal property under the Money Laundering Act, to now criminalize it. So it's a point that I make. I call it the MLA POCA cusp, because it falls right between the two. And what can happen is a transaction can fall between the two stools. It can neither be MLA or POCA.
And you say that's just a lacuna in the statutory provisions, do you?
Well, I think the way Parliament wrote it that way, so as not to infringe with the no retroactive penal statutes provision. But for whatever reason they did, that is what they did. Because I understand that the English POCA is different. But Parliament in Jamaica did it that way. So it was important when this warrant is being applied for us. So the ARA cases, it really looms large in this determination. It is what convinced the Court of Appeal that the pre-POCA offending ought not to be included. So it looms very large in this case. And my learned friends have provided no argument to distinguish it.
Well, the necessity for us to decide whether or not, under the Money Laundering Act, both the antecedent event and the transaction have to occur before the 30th of May 2007 isn't really before us. And I would need to have a look at the Money Laundering Act to see whether or not the transaction is required to take place before the 30th of May, because I could easily conceive that whilst the antecedent event might have to take place in that timescale, I see no reason at all at the moment why the transaction subsequently can take place afterwards.
May I say why it can, Manuel?
Yes.
The Money Laundering Act was repealed by the Post of Crime Act. So therefore, the 25(2) of the Interpretation Act preserves liabilities incurred. You incur no liability merely for one half of the money laundering offense. The money laundering offense is made when two parts come together, predicate and concealing or the laundering. So therefore, if you have criminal property, the predicate,
If I could interrupt.
Yes, my lord.
Section 25 refers to any liability
Yes.
acquired under an enactment so repealed.
Yes.
So you look to the enactment
Indeed.
to see what the liability is.
Yes.
And we haven't been taken to that enactment to show that the liability only arises if the transaction also occurs before the 30th of May 2007.
Yes.
I'd be surprised if it did, because otherwise there would be a lacuna in the law, as has been pointed
But my
out.
lord, if I may, the nature of money laundering, that it's a two-part offense. And the second part being what we call the laundering of the first part, criminal property. Under the Money Laundering Act regime, you can have criminal property created. For you to criminalize it under the Money Laundering Act and to incur liability, it must mean that the second part would have to be committed whilst the act is in force. The act cannot be repealed and be enforced at the same time. So the act, once being repealed, cannot speak to laundering that takes place after it's repealed. I'm saying it's a matter of the effect of the repeal, because no liability is created merely by the predicate. Which is, and I do make this out in the written submissions by references to GH. Let me take your lordship to where that is in the I'm sorry. The same is said in asset recovery, but let me take you to where that is said in GH. Paragraph 18 of my written submissions refers to GH from the UK Supreme Court 2015, which make it clear that the money laundering offense is unique in that it concerns predicate property, and it criminalizes the doing something with property from the predicate offense. So the doing something with must be penalized under the regime of a statute, and the regime of the statute cannot continue after the statute is repealed. It would be like, my lord, in Jamaica, we at one stage we had we created a Sexual Offences Act, which renamed some offences. And if somebody for historic sexual offense done in the 1980s, they could be prosecuted under that act, but they cannot be prosecuted under that repealed act for something done yesterday or last year, because the repealed act is no longer in force to criminalize current behavior.
But you would have no problem, as I understand your submission, if the second part of this two-part offence had taken place before May the 30th, 2007.
Indeed, my lord. That's a complete offence justiciable under the Money Laundering Act. The trouble is in this case is that there is no such distinction in the evidence put before the warrant judge. Whether deliberately or through carelessness, the warrant judge was misled and not given all the facts on this crucial issue, which goes to, is there in fact an investigation under POCA? And what happened is the warrant judge was not able to consider an important issue that she had to consider. But it also touches on the issue of privilege, which the exception that was relied on was that it's in furtherance of a criminal or fraudulent purpose. And at paragraph 27, I set out the law on that, which I don't think anyone is disputing. At paragraph 28, I make the point that before the warrant judge, we don't know how the issue of legal privilege was treated with. We don't know because there is no decision. When the issue of background evidence was introduced before Madam Justice Straw, her ladyship went back to an issue which is at, I say at paragraph 15 of her judgment, at paragraph 28. That is a mistake, my lords, I'm very sorry. It's at paragraph 43 to 44 of her ladyship's judgment, which your lordship can see at 139 of the decision. This is where her ladyship is grappling with, is there evidence to overthrow the privilege? And at paragraph 44, she relates an issue which my learned friend, Mr. Mitchell of Queen's Counsel, dealt with. This issue about transactions with fictitious persons. And that is the reason that she used to find that there were these sham transactions. Now, the trouble with that is, which I make out at paragraph 29, is that at the actual trial, this so-called sham evidence was put before the court. It included, the evidence came from an American witness and a computer-generated evidence, and it included a banner that said, the public records and commercially available data sources using this system have errors. Data is sometimes entered poorly, processed incorrectly, and is generally not free from defect. So they were trying to prove that these Americans who were the parties to these transactions were fictitious people not living at these addresses in America. But at trial, it turned out that the data that they were relying on had inherent weakness. Well, it's good that it was revealed at the trial. That ought to have been in the affidavit for the warrant.
Would the MOCA know about those inherent weaknesses at the time?
Indeed, my lord, because this is where that information came from.
They got the information from there, but it was established, you say, at a trial which is still ongoing.
I'm sorry.
That there were defects in the software.
Their witness produced an exhibit which was proving how he had searched, I think it was the post office database in America, to determine whether or not these persons actually live in where they said they live in America. So it was his exhibit, the exhibit of their witness. And the exhibit said that the data is prone to error. Now that is something I submit ought to have been put before the warrant judge. And that is a clear failing duty of candor. And it goes to a crucial issue, because that was the crucial evidence which overthrew the privilege. But of course...
So you're introducing evidence that's taken place at the trial.
Indeed,
yeah. Yes. Was there any evidence at the trial through cross-examination that those people actually lived there at the right address? That they weren't fictitious? That they were real?
You mean evidence at the trial of a positive nature?
Yes.
I would say, I can say, well, I was not involved at that stage of the trial. In fact, I have not been involved in any stage of the trial which has actually taken evidence.
Right.
I've been in the trial 2 years, and we have been caught up in
You're still on the Crown's case, aren't you?
I'm sorry,
Still the Crown's case.
We're in the Crown's case, but I don't think any evidence has been taken since I have been involved.
Yeah, but you were being asked about the cross-examination of the Crown witnesses, but your involvement is not such that you can answer the question.
I was not involved. I believe at that stage, Mr. Frank Phipps might have been appearing, but he has since retired. And since he retired, I have tried to take up the mantle. But the privilege argument, this may very be near to the end of my submission. The privilege argument has another problem, which is to overthrow the privilege, there must be some prima facie evidence, good prima facie evidence of criminal conduct. And again, given this MLA poker border and cusp, there is a great problem in that regard. I can make two quick final points, my Lord, before I sum up.
Just before you do, you made the submission both before and after the short adjournment that a poker offence, a money laundering offence, whether under Poker or the Money Laundering Act, is a sort of two-stage offence.
Yes.
You first got to create or acquire or render criminal property.
Yes.
And then you've got to deal with it or launder it.
Yes.
But if you look at section 92 of Poker, and I'm not able to look, I think, at the Money Laundering Act, on page 685, and remind yourself that the definition of criminal property is in section, I think, 91.
Yes.
It seems that the offence is committed in relation to property if you engage in a transaction that involves it, conceal, disguise, etc., or convert or transfer or remove it from Jamaica.
Yes.
And the predicate is only that at the time when you do any of those things, the property is, by then, criminal property.
Indeed.
But why should the date upon which the property became criminal property have to follow the passing of the Act?
Because the Act says so. The Act defines criminal property as coming from criminal conduct after the 30th of May 2007.
And where do we find the after bit?
Let me see if I can take your logic to that directly.
Section 210, Lord.
Section
210.
210?
And you'll find that, forgive me, I should get up. Your Lordships will find that at page 677.
677. Thank you very much.
Sorry.
As I'm referring for his assistance.
Well, I'm not entirely certain it's 210.
210?
2 subsection 10, is
Yes,
it?
section 2, subsection 10 at page 677.
Oh, because the reference to offence is committed.
Yeah.
5, 6, 7, 21, 22, 30. But
I thought it was more to do with the definition of criminal conduct,
yes,
Which
is in section 2, subsection 1.
It's in more than one place, my lord, that reference to, if I just open my...
How does section 210 read into section 91?
I thought it was just the ancillary powers. I haven't looked through all those powers, voidable transfers, reconsideration.
Lordship is of course right. Sorry.
Yes, yes, it's section 2.1.
Section 2.
Subsection 1.
1, definition of criminal conduct. And forgive me, I was too fast to my feet, because section 210 then takes that on as a definition by reference to the various sections as to when you can, although it doesn't mention section 90.
But it appears to be that you have to have both the actual criminal conduct and the transaction after the 30th of May under POCA. But the other side question is whether you have to have both before the 30th of May under the previous statute. And really,
I agree, and the Money Laundering Act is in the bundle, laws beginning at page 649.
You're unlikely to find it there. I mean, the submission made there is the Act was simply repealed on the 30th.
Well, and we can't, we're struggling to find the repealing provision in POCA. Yes, we're trying to find the repealing provision.
My Lords, I believe I set these out in.
Sorry.
I'm looking for where I set these out in my submissions. The actual, but my friend has. I'm happy to hear has agreed with me that it does require criminal property to be created after the 30th of May 2007. So for the moment, no. For the moment, I cannot seem to find where it is actually in my where actually it is in my submission, but I'm happy that it is not. That there's no disagreement thereon. MG and T, relied on by learned friend, the extradition case from Sweden. It's a significant different situation to say that you may have committed an offense, but Limitation Act prevents prosecution, than to say there is a date which defines from when you can commit an offense. And I don't think MG&T assists in that. And indeed, in MG&T, the question was, as in all of the background evidence cases, is background evidence admissible at trial? Is it relevant and admissible at trial? And I would make the point that I made earlier, that the question is not that. The question, is it relevant to the investigation? And I made that point earlier, and I won't delay any further on that. My last point is, I know my lords have asked the question about possibly new issues arising in my submissions. And in the break, I have been shown Delahaye versus Air Mauritius. Delahaye versus Air Mauritius, which is 2018 UKPC 14, where the board has adopted a liberal approach to new material being argued before the board, where it can be done without injustice. I would suggest is the leading proposition at paragraph 17 to 18. I could send copies by electronic mail afterwards if that is allowed. The thing in this case is that we are, the reason why I say there is no injustice is that we are trying to tackle the issue of privilege and the issue of the validity of whether the access conditions were met for this material. And central to that is the public interest test, and central to that are the constitutional requirements. What I would pray is that if your lordships do not agree with me, that your lordships send that issue back to the Court of Appeal. Because it cannot be right that, that this was raised by the first respondent and the Court of Appeal simply says, as I pointed out to your lordships, we will not answer that at this time. That cannot be appropriate. And it cannot be appropriate that the first respondent was forced to argue a case before the Court of Appeal without the aid of counsel and trying her best to do so because her assets were restrained by the state and she could not get any legal assistance.
What paragraph number is it of the De La Haye case?
Paragraph 18.
17.
And 18, my lord. 2018 UKPC 14, my lord, if maybe. And I continue to rely on those cases which I made mention earlier, where the option has been to deal with it or to send it back for that point. And I also referred to the recent CCJ decision in Solomon Marin, where the CCJ essentially said, where a constitutional issue arises centrally in a matter to be deliberated by the final court, the final court ought to take on that issue. And we say that in this case, the application for the warrant was so in such breaches of the basic principles that it cannot be fair for anything from that warrant to be made available, much less, much more background evidence. There's an expression that my mother used to tell me that what go on bad from morning can't go good at evening, which means, I was what it means. I'm sure you understand what it means. If you're wrong, essentially from the start, it cannot be improved upon. And so, if I were to list the wrongs, it is the case needed to have been grounded in poker. The difficulties therein should have been brought centrally to the warrant judge. This point about sham transactions, the weakness of it ought to have been pointed out. And those are inexcusable. But of course, I would also rest on my initial argument that applying asset recovery and BBC background evidence is not part of what is recognized as under a search warrant as being relevant under a search warrant. Those are my submissions, my lord, unless I can assist the board in any way.
Thank you very much, Mr. Williams. Mr. Wilkinson.
I might be audacious enough to say that my learned friend, Mr. Williams, was kept in the pavilion with pads on, if I might adopt his my lord's an umpire signal and no ball shot. My lord will say, my learned friend Mr. Williams in his inimitable fashion has kept me in the pavilion, as I was saying. And if I might be audacious enough to say that take the shine off the ball in my respectful view, it's a matter for your lordships, in commendable fashion, and I think has made my work much easier, so that I am constrained to say I adopt his submissions as far as they're germane or relevant to my clients, the second and third respondents. Yes, I think Mr. Williams has batted, your lordships would be quite au fait with one Graham Allen Gooch, who can't forget Lord's 1990, 333 and 123. That's Mr. Williams. That's my humble view. And I would, in the style of Sir Cuthbert Gordon Greenwich. But be that as it may, my lord, and that having been said, I'd like to say ab initio that the submissions by the appellant, both which fell from the lips of my learned friend, Queen's Counsel Mr. Mitchell and Queen's Counsel Mr. C. I think I maintain our written submission, which your lordships have read, which you have indicated to us, that those submissions from the appellant, in our view, they lack merit. And we maintain that, which was enunciated in our written submissions. And we say they lack merit for a number of reasons, one of which your lordships will appreciate, is that we think those submissions are based on what I would call an inglorious fishing expedition. Perhaps inglorious is redundant. Can a fishing expedition be anything but? That's for another time. But be that as it may, I'd like to make that point up front, that these submissions from the appellant, I think, indubitably they must fail, because, my lords, I have taken a slightly different approach from my learned friend, Mr. Williams, in addressing our submissions. And I will deal with it now. In relation to the history of the matter, your lordships haven't read the documents. I can take you directly to paragraph 14 of our submission, which is on page 4. And our submissions can be found, respectfully, my lords, at the electronic bundle 0428. Page 0428. Our submissions comment. And in the interest of time, I could go directly to paragraph 14, where I would like to highlight the questions which were before the court below, Honorable Court of Appeal of Jamaica. And those questions which were sought to be certified for argument before this honorable board, they are set out at paragraph 15, A and B. Namely, whether, in the case of a money laundering investigation, background evidence, the Petman principle, must amount to a criminal offense to be relevant to the investigation. And also whether, in the case of a money laundering prosecution, background evidence, the same Petman principle must amount to criminal conduct within the meaning of Section 2 of the Proceeds of Crime Act, which your lordships just had the benefit of discussing, albeit fairly briefly. And if we, at paragraph 16 of our submissions, we quote, if it pleases you, my lords, from the judgment of Judge of Appeal, Justice of Appeal Phillips, which is a lead judgment of the court below. And we highlight paragraph 52. Now, in the interest of time, I will not read that extensive paragraph, which begins, I would conclude. And that paragraph, my lords, if you wish, can be found at the digital or electronic bundle at page 328, 0328. And that is paragraph 52 of the judgment of the Court of Appeal. And this was what the court said in not granting leave to the appellant, which leave, I said, your lordships, in a most generous, in a burst of generosity accorded to the appellant, as you thought, fit in your infinite wisdom. But be that as it may, the Court of Appeal justified why it never granted leave. So, these questions have returned, and I won't say to haunt us, but I say they have returned before this honorable court. And these are in the form of the new questions, which I highlight from the appellant's submissions or written case. And these questions I've put at paragraph 23 of our submissions. But before I turn to paragraph 23, my lords, I would like to address two things which my learned friend, Queen's Counsel Mr. Mitchell, raised in his submissions. Firstly, he sought to take your lordships to this affidavit in support, which generated the search warrant from Her Ladyship, Madam Justice MacDonald Bishop, as she then was. She's now, of course, in the Court of Appeal of Jamaica. And he urges your lordships to read the affidavit, which your lordship said you will do, of course. But I wanted to emphasize, firstly, that that affidavit contained hearsay material, as you will see, And I'm trying to remember, it's my Lord Stevens who asked a question if about an indictment and so on, and my learned friend Mr. Mitchell sought to send it to the board. But as a general rule, I am loath to have matters sent to a tribunal which has not been the subject of submissions, be that as it may. The indictment itself, the affiant, who's the appellant here, made it abundantly clear that that was not available. It was not exhibited to that affidavit, if I recall correctly. I think, in fact, the affidavit referred to its absence. But even so, my lords, the indictment is different from a certificate of conviction. So even if the indictment had been exhibited, there was no certificate from the respective jurisdiction to indicate what exactly was this person convicted of. So our complaint was, it's not correct to refer to somebody as a drug dealer unless you can prove it. And we maintain our position, regardless of what my learned friend Mr. Mitchell would like to advance, that this is the case. And your lordship will see it when you read the material. It is there for your consumption, respectfully. Now, the second point I'd like to make, and I differ slightly from my learned friend Mr. Williams in this respect, even though he's quite candid with the court that he has not been involved. I have been involved with the trial, so has my learned junior, Mr. Stewart, to some extent. But we take issue with the fact that a number of things which have taken place at the part-heard criminal trial were placed in the material before this honorable board and done in a way which was prejudicial in our respectful view, or purported to be. Fortunately, in every dark cloud there is a silver lining, and our silver lining is that there is an admission by my learned friends that 9 of the properties for which certificates of titles were exhibited or placed before His Honor, former resident magistrate, now parish judge, as we change our laws in terms of the nomenclature. Those 9 titles predated POCA. So the registration, and my learned friend Queen's Counsel Mrs. Say referred to Section 88 of the Registration of Titles Act, but be that as it may, we think respectfully that that is de minimis in the context of this appeal. We maintain, humbly, that those 9 titles predating POCA, I might call it that for short, support our position. And the very position highlighted by this honorable board in, if I might call it for short, the assets recovery case ex parte Jamaica, judgment for which was delivered in January 2015. Lord Hughes delivering that seminal judgment of this board. So I wanted to make the point that the trial is part heard, and I think, even though my learned friend Mr. Williams touched on it, but admitted that he really wasn't involved too much, I really don't want to touch on that trial at all, because I think we ought not to do that, respectfully, because it's part heard. The Crown has not even closed its case. Many witnesses would still have to be cross-examined, among other things, and we don't know what will happen there. We don't know how the court will rule. So when my learned friend speaks to unchallenged, there are matters which are still live. When they say unchallenged, it is not unchallenged in the sense that it is accepted. I want to make that abundantly clear. Any decent chess player would know one time when you sacrifice on H7 or G7 or H6. My learned friends have uncorked what we would call a dubious or unsound sacrifice. It cannot work. And consequently, ergo, this allegation, or these allegations, let's leave the plural, and I commend my learned friend, Mrs. Say, for that. Because in her conduct with this court, she consistently used the word allegations. That's all they are, my lords. Nothing more, nothing less. And that is why we have to tread very cautiously in how we approach that material before a court which is still undecided. And that's a very, very interesting point. So what we can glean from what my learned friends have put before your lordships, with which we are forced to contend, is that at least they have admitted that 9 of the properties predate, the registration for those predate the Proceeds of Crime Act, 30th of May 2007, which is a very important fact which inures to our benefit. Now, if I might turn, my lords, if it pleases you, to paragraph 23 of our submissions, second and third respondents, which treat with the new questions now. I spoke to the questions which were before the Court of Appeal, which were 2 questions. My learned friend for the appellant has now lifted and improved that to 3. Now, the first question is similar to the first question which was before the Court of Appeal at 23 Roman 1, except at the end, the appellant now appends and attaches in parentheses, and therefore qualifies material to be produced under production order. They have developed that question. And on the 2, they refer, same question, but at the end, they add, which came into force 30th May in relation to conduct on or after that date. And then they introduce a third, which was not before the Court of Appeal below, and I highlight that it was not before the Court of Appeal below. Investigations generally, the consequence of upholding the decision of the Court of Appeal would be to deny investigators the right to seek material in an investigation that might inform the inquiry. Otherwise, according to law, if that material predates commencement of the legislation which creates the offense. I have decided for simplicity and to assist this court as best as possible, to deal with these seriatim in the order in which my learned friends have sought to put them before this court. Now, if I might turn to paragraph 25 of our submissions, it is our humble view that by this very appeal, which is before your lordships, what this appellant is trying to do is to invite this honorable board to ignore unjustifiably one of its fairly recent decisions regarding poker. It is inviting this board to arrogate unto itself the powers of Jamaica's parliament and essentially rewrite the clear words of parts of a Jamaican statute. And my lords, we didn't bother to belabor you with what is clearly trite law, that where the words of a statute are clear and unambiguous. It's one of the simplest of rules of legal interpretation. Even a first-year law school student understands that. So we didn't bother to cite authorities for that proposition. So that is the second thing. And we're saying, thirdly, that they want to permit them to pursue a course which is forbidden by the said statute. So, among other things, they want this board to rewrite section 2, subsection 1 of the statute poker, which states, criminal conduct means conduct occurring on or after the 30th of May 2007. And it speaks for itself, I won't belabor that. But my lords, we can't stop just there. I would like to highlight what has not been highlighted hitherto. Namely, under paragraph 27, reference to general criminal conduct, which the Proceeds of Crime Act also states that in relation to a defendant, it means all the defendant's criminal conduct occurring after 30th of May 2007. And further, my lords, at paragraph 28, in relation to particular criminal conduct. So there are 3 species, or whether you want to call it, whatever you want to name it, branches.
37 of what, sorry? 37 or 38? This is of your argument?
Yes.
Paragraph 28.
27.
The paragraphs of your
Yeah, sorry.
26, 27, and 28.
You're quoting from the definition section.
Yes, my lords.
Yes. Yeah.
Much obliged to my lordships.
Yeah.
And it says, so I'm highlighting that we have been concentrating generally on criminal conduct, but the statute dealt with the thing in greater detail. It broke it down into the nuts and bolts of what is general criminal conduct, what is particular criminal conduct. But in every instance, what do we have? We have the hub, the nub, the fulcrum, 30th of May 2007. That is an indispensable reference point, absolutely indispensable. And so it is our humble view that what the appellant wishes to do, and I'm at paragraph 29 of my lords, of my submissions, they want to adduce so-called background evidence which predates poker to prove or support the proof of criminal charges against the respondents in the said part heard criminal trial in the parish court. And this is what the Court of Appeal said, no, but you can't do that. No, I pause here, my lords, because the Court of Appeal in absolutely no way said the Petman principle is over, we are overruling the Petman principle, or that you cannot introduce background evidence. The Court of Appeal never said that. And that is why it is our humble view that this appeal is misconceived, because they have put questions to your lordships, which are questions which need not even be answered, really, because they are irrelevant questions. They don't even arise. If you look at the Court of Appeal decision below, and Justice Phillips, who, if I might say it with your permission, dealt with the matters quite sagaciously in the Court of Appeal. When you look at the well-reasoned judgment from the Court of Appeal, she said, listen, I'm not stopping you from using background evidence, but her ladyship placed heavy reliance on your lordship's decision in the assets recovery judgment ex parte Jamaica case, Lord Hughes's judgment representing the board's ideas and decisions. She quoted extensively from it, and I will return to it. My learned friend, Mr. Williams, dealt with it. And you know, my lords, if I might just pause, Mr. Mitchell complained, well, complained is my word, that I said that he dealt with that case en passant. And he's correct. I said it, and I stand by it with even more force and vigor, having heard his submissions today. That he dodged it. One remembers Jack Hawkins, Dickens's Jack Hawkins, well, popularly known as the Artful Dodger. Well, let me use that. Let me not use the Artful Dodger, because that was tinged with some criminality. And I wouldn't want to ascribe that to my learning. Absolutely not. Let's say he dodged it like, may I go back to another quick term, Jeffrey Boycott. Your lordships remember that over from Michael Holden, my lord, Kensington Oval, 1981? And Jeffrey Hope dodging and bobbing and weaving. That is exactly what Mr. Mitchell was doing. He was bobbing and weaving from the Asset Recovery Agent's case from this very court. Why is that so? There were some unplayable deliveries coming from that judgment. The first over I've ever seen where you have pace bowling and googlies all in one, and none of them could be touched by Mr. Mitchell. Unbattable. You know, we needed the power of Gooch here, or the Prince Brian Lara, or my favorite Ivy Richards. But be that as it may, he couldn't, because this case guides us. And my learned friend Mr. Williams was correct. Yes, it dealt with CIOs, information orders, but the principles enunciated by this board through Lord Hughes's mouth and or pen, they are seminal, they stand relatively young, just 7 years ago, but they are very germane to these issues before your lordships. So I touch on that at paragraph 31 of my submissions, and in the interest of time, I don't need to revisit it, I've already dealt with it. My Lord Hodge was a member of that board which dealt with that case, so your lordship would be quite au fait with that judgment. And to show that the Court of Appeal of Jamaica had their lordships, Justice Williams, Justice P. Williams, Justice Frank Williams, and her ladyship, Justice Phillips, at paragraph 74 of the main judgment, as I call it, which is on appeal here. And that can be found at the electronic bundle, page 0268 of that. That's page 0268 of the bundle, paragraph 74. The Court of Appeal actually quoted Lord Hughes. Page 0268, my lords. The Court of Appeal quoted Lord Hughes at paragraph 22 of the said case, to the effect that Roman 4, the assertions of suspected criminal behavior where made included much which was said to have taken place before 30 May 2007. Included much which was said to have taken place before 30 May 2007, and thus which could not have been criminal conduct, and could not have generated criminal property for the purposes of the Proceeds of Crime Act 2007. See Section 2, subsection 1. Now, my lords, a little later, I will turn to criminal property in the context of what His Lordship, Lord Hughes, said here. My lords, to put it under the microscope. And if you put this beacon, this searchlight on the appellant submissions, and put those submissions under the microscope, what do we have here? At least in this case before the board back in 2015 when that judgment was being handed down in January, case was heard a little earlier. They at least knew what the material was. In this case, the appellant, they don't even know. Because as Mr. Mitchell said, what was seized is still sealed. And that is why I call it an inglorious fishing expedition. Now, this is important, my lord, because this criminal trial, which is ongoing and part heard, as Mr. Mitchell also told you, continuing in September, in 3 months' time approximately. This trial was started, my junior, Mr. Stewart, was giving me the exact dates, I think in December 2017. So they were charged in December 2013. So these people were charged approaching 9 years, and the trial started almost 4 years later, when there was significant pressure and applications made to strike it out for want of prosecution. So they had to start because they got the criminal law equivalent of an unless order, in essence. And they have pursued. So if you start a case, you must have the material to finish it. You can't rely on what we used to call a pig in a poke or a puss in a bag. You don't know what is there. You must have the material. Why are you charging me if you can't prove me guilty? Why do you need to wait until what is unsealed to try and find something? You don't even know if what is there is all pre-2007, 30 May 2007. At least in the matter before the board back in 2014 into 2015, they knew what was there when the CIO was being pursued. It's not even that in this case, which in our respectful view renders it so tenuous, not even tenuous, it's non-existent, this case from the appellant. It's like wisp in the wind, with the greatest of respect. And my lord, if I might now move to paragraph 34 of my submissions, where we say Jamaica's POCA is unique, sui generis. Criminal conduct, it cannot be cannot be overemphasized. Criminal conduct in POCA is unique to Jamaica. This statute from 2007, in the land of wood and water, essentially captured in large measures the United Kingdom Statute of 2002. But it introduced a number of changes, and this was one of them. It circumscribed the offenses you can bring under the statute by that particular date. And all the Court of Appeal below was doing was to say, yes, Court of Appeal didn't prevent the appellant from the material seized being searched, my lords. Said you can search. Whoever the system judge is going to be, if he or she, and I agree with the questions, I think it might have been possibly my lord Burrs or Briggs, I'm not certain, but might have asked in relation to whether the issue more concerns privilege attaches. That's what the sifting judge has to decide, whether it's a privilege attaches, not issues of admissibility and so on and so forth. You're really determining are these privileged or not. So in our respectful view, what the Court of Appeal was saying is, you can search. I'm not preventing you from searching. But Justice Straw never dealt with this aspect properly. And here we are as a higher court giving you the necessary guidance and direction. Deal with it in this particular fashion. That's what the court was saying. And it is our humble submission that the court was not in error and its decision ought not to be disturbed by this honorable board. So, at paragraph 36 of our submissions, we say the definition of criminal conduct in Jamaica's POCA has been described by the Jamaica Court of Appeal as being, and I quote, closed and unequivocal in the instructive case of Norris Nemhard against the Asset Recovery Agency, reported, my lords, that at 2019 Jamaica Court of Appeal at page 30. That can be found at the electronic bundle 0884. That's electronic bundle 0884. And I'm not going to delay your lordships with this much, save and except to say that this was a judgment of the Court of Appeal, and curiously, it was delivered on the very date the judgment being appealed against in this case was delivered. Justice Phillips also sat on that case, and curiously, Justice MacDonald Bishop also sat in the Court of Appeal. You recall Justice MacDonald Bishop was the judge who issued the search warrant. And at paragraph 41 and 45, those are the two paragraphs I'd like to extract. Now, paragraph 41 of the Norris Nemhard decision, my lords, can be found at 0901 of the electronic bundle, 0901. And for your lordship's benefit, I've quoted the paragraph. It says, not only is Parliament obviously deliberate in speaking to criminal conduct as distinct from unlawful conduct, is that also defined both concepts in separate and discrete provisions. Also went even further to make specific provisions concerning the limitation of actions on the part 4 of POCA in relation to unlawful conduct. And at 45, paragraph 45 of the Norris Nemhard judgment, my lords, which can be found at EB, electronic bundle 0903. 0903, that's where we find paragraph 45. It stated, their lordships in the Court of Appeal says the definition of criminal conduct in section 2, subsection 1, relied on by the applicant has no bearing on the civil recovery regime provided by part 4 of the Proceeds of Crime Act. The respondent's cause of action would have accrued at the time the property alleged to have been obtained through unlawful conduct was acquired. This could have been prior to the passing of the POCA. The applicant cannot successfully rely on section 2 to escape the tentacles of the civil recovery regime invoked by the respondent. So my lord, here we see this honorable court drawing a distinction between the civil and the criminal regimes, not dissimilar to what we have seen extracted from the judgment of this honorable board in the Assets Recovery Ex parte Jamaica case, which dealt with the Customer Information Order, or CIO. No, so that is our respectful view, and I now turn to some questions were asked by your lordships of my learned friend, Mr. Williams. I don't know if I can be of much more assistance, but I will try in relation to paragraph 37 of our submissions. Jamaica's Repeal Money Laundering Act, which was Act number 30 of 1996, became law January 5, 1998. And this statute, my lords, can be found at the digital bundle 0649, 0649, my lords. And this section from which I'm quoting is section 3, subsection 2. And that can be found at 0651. And it's a very brief quotation. It says, a person who, after the 5th of January, 1998, engages in money laundering is guilty of an offense and is liable, and I stop there. So we see these two statutes. POCA refers to the 30th of May, 2007, and the Money Laundering Act, the 5th of January, 1998. Now, I too have checked, and I didn't see, I'm still going to double check. If there's a specific wording which says, Proceeds of Crime Act hereby revokes the Money Laundering Act of 1998, Act number 30 of 1996. I don't recall seeing that spelled out in the early sections of POCA, but the effect of it has. And in fact, POCA itself now assumes the jurisdiction and deals extensively with money laundering, my lord. So I don't think it's an issue. My learned friend has conceded that it has been repealed, so I'm not going to belabor that point. But I make the following submissions, especially bearing in mind what Mr. Mitchell said in seeking to distinguish some of what my learned friend Mr. Williams said. At paragraph 38 of our submissions, the effect we submit of both Section 2 of POCA, which defines criminal conduct, and Section 3, subsection 2 of the Repeal the Money Laundering Act, is that criminal culpability can flow under those statutes for actions or conduct occurring only after the appointed day. So in the Money Laundering Act case, it is 5th of January 1998, and in POCA's case, 30th of May 2007. And bear in mind a couple of questions which were sent down the pitch at my learned friend Mr. Williams in Michael Holding fashion. But unlike Jeffrey Boycott, who went low and lost his helmet more than once, Mr. Williams held a straight bat, if I might say so, and fended them very well. And I would say, in using that analogous argument, my lords, in relation to the Money Laundering Act, if events had occurred prior to the 5th of January 1998, they would have fallen afoul of that statute. I think that goes without saying. So I won't belabor that point. I think it's palpable, respectfully. So we continue at paragraph 39 of our submissions on page 10, that it is submitted that criminal offences have been deliberately phrased in both POCA and the Repeal Money Laundering Act to give effect to the time-hallowed principle that statutes should not ordinarily be construed to have retrospective effect unless the intention of the legislature is clearly expressed, and that no person should be found guilty of a criminal offence which was not an offence at the time the act or conduct occurred. And we will look at this a little later. And your lordships engage my learned friends in I wouldn't call it an exegesis, but a little brief discourse on that point. Now, my lord, I said I would return to this, and I'm here now. What is criminal property? Because in my humble view, we cannot look only at criminal conduct in isolation. We have to juxtapose it with what is criminal property. And I advert your lordship's attention to the Proceeds of Crime Act, which can be found at page 0665 of the bundle, 0665. And I'm going to refer particularly to section 91, subsection 1, paragraph A, which was dealt with earlier. And that quotation I have at paragraph 40 of my submissions. And that section 91 can be found at page 0679 of the electronic bundle. And what does it say? The statute reads, pleases you, for the purposes of this part, property is criminal property if it constitutes a person's benefit from criminal conduct or represents such a benefit in whole or in part, and whether directly or indirectly, and it is immaterial who carried out or benefited from the conduct. So if you look at the first few words, property is criminal property if it constitutes a person's benefit from criminal conduct. They are inextricably linked. They are umbilically linked. You can't separate the two, my lords. So it's not just in isolation you're looking at criminal conduct. You have to look at criminal property. And there is a nexus between section 2 and section 91. And of course, this provision was quoted by Justice Phillips in the lead judgment in the Court of Appeals judgment, which is under siege, unjustifiably so, if I might add. Now, in the main judgment from the Court of Appeal below, and I refer to the main judgment because I refer to two judgments, the main judgment on appeal here, and what I call a leave judgment, where the court refused leave to my learned friends. Again, justifiably so, but that's a matter for your lordships. At paragraph 38, Justice Phillips quoted the provisions of section 92, subsection 1, and I've now moved from section 91 to section 92. And section 92, my lords, of the Proceeds of Crime Act can be found at the electronic bundle at page 685, 0685. And it reads, and I think it's worth repeating, subject to subsection 4, a person commits an offense if that person, quote, A, engages in a transaction that involves criminal property. So we get back into criminal property, which was defined earlier under section 91. B, conceals, disguises, or disposes of, or brings into Jamaica any such property. Or C, converts, transfers, or removes any such property from Jamaica. And the person knows or has reasonable grounds to believe at the time he does any act refer to in paragraphs A, B, or C that the property is criminal property. And subsection 2, subject to subsection 4, a person commits an offense if that person enters into or becomes concerned in an arrangement that the person knows or has reasonable grounds to believe facilitates, by whatever means, the acquisition, retention, use, or control of criminal property by on behalf of another person. For the purposes of this section, concealing or disguising property includes concealing, disguising the nature of the property, its source, location, disposition, movement, ownership, or any rights with respect to the property. I pause, my lords, because these sections are very important, because you would have heard my learned friend, Mr. Mitchell, you would have seen the submission from the appellant. These sections are relevant to the charges in the criminal matter still part heard in the parish court, halfway tree, St. Andrew, Jamaica, Kingston, St. Andrew. And I close with Justice Phillips at paragraph 39 of the case now, which the main judgment, as I keep referring to it, just in case your lordship wish to refer for reference, is found at 0226. That's where the Court of Appeals judgment is. You would have seen it, of course. And her ladyship referred to section 93. So we're taking them one after the other. 91, 92, and 93. Subsection 1 of 93, which states, subject to subsections 2 and 3, a person commits an offense if that person acquires, uses, or has possession of criminal property, and the person knows or has reasonable grounds to believe that the property is criminal property. And that quotation from the statute is at 0250 of the electronic bundle. 0250, your lordships can find section 93, subsection 1. Now, I link all of that, my lords, at paragraph 44 of my submissions next, when I say we submit respectfully that it is clear. My learned friend, Queen's Counsel, Mr. Witter, who's not before us today, would say it's pellucid. Those just above quoted sections deal expansively with what is criminal property. And these said sections must be read together with section 2 of the Proceeds of Crime Act. And I finish the point by emphasizing at paragraph 45 of our submissions that it is our respectful opinion also that there is this what I like to call, my lords, an umbilical nexus between the definition of criminal conduct and criminal property. And your lordships now would understand why I've said that, having taken you through sections 2, 91, 92, and 93, respectively, of the Proceeds of Crime Act. In other words, there can be no criminal property without criminal conduct. That is my humble interpretation or construction of the germane provisions. This inextricable link is very important and also provides indisputable and irrefutable justification for the Court of Appeal's correct decision. These sections, my lord, they are joined at the hip, at the pelvis, at the pubis, whichever you want to call it. They are joined inextricably, just like a famous pair of Siamese twins. Now, I move, my lords, to paragraph 46. When I'm looking now directly at the first question, I look at the first, having set the foundation, my lords, we have paved the pitch, we're about to bat and bowl at the same time. The appellant first question, which I set out earlier, which was stated at paragraph 2, page 2 of their submissions, and quoted, if you wish to refer to it, my lord, we quoted it in paragraph 23 of our submissions. We submit humbly that at absolutely no time, did the Court of Appeal rule or state that investigators could not make use of background evidence in the investigation. Similarly, the Court of Appeal did not rule or state that background evidence must amount to a criminal offense in order to have relevance to an investigation. If you look in that judgment, you'll find that absolutely nowhere. Absolutely nowhere. And I think the appellant essentially concedes that in their submissions. Now, if that is so, how then are we faced, and this honorable board is faced with resolving the question of a money laundering investigation must amount to a criminal offense to be relevant? Why is that question posited? Court of Appeal never dealt with that or said that. So if the Court of Appeal had said that, emphatically, then you could see why you're challenging or putting that as a proposition for this board to resolve. I said, no, but Court of Appeal, you said that. How could you? The law doesn't say that. you would have fallen in error, and then you could see an appellant come into your lordships in supplication seeking justice. But the Court of Appeal never said that, so how did we get here? Why is that before you? I submit respectfully, it's like wisps, wind in the willows, with apologies to the famous author. It's candles in the wind. We therefore agree with paragraph 30 of the appellant's written case, insofar as it states that there appears to be no statement of legal principle that background information must be evidence of criminal acts. That's what I just referred to. I put it there just for the avoidance of doubt for your lordships, paragraph 47. The appellant said so in their own submissions at paragraph 30, that there appears to be no statement of legal principle that must be. The Court of Appeal never said it. There was no such statement. So if you're agreeing or admitting that, why are you making this a ground of appeal? 48, my lords, that's paragraph 48 of my submissions. The appellant has not established what she contends in paragraph 31 of her written case. In any event, the appellant's submission, and my lord, to be fair to my learned friends and to your lordships, what paragraph 31 of the appellant's case says, it says it is submitted at the Court of Appeal, and they refer to paragraph 87, erred in holding that to adduce such evidence and investigation should have been commenced under the Repeal Act, when the acts sought to be inquired into are relevant to the matter presently before the court, and are not the subject of specific charges, but avoid the creation of artificiality. My lord, I don't wish to speculate, because I can't say what was in my learned friend's mind, or even the affiant Bobette Smalling's mind when she did that affidavit back in December 2013. But I agree with my learned friend, Mr. Williams, again. I think what has happened is that the appellant, or those representing the appellant, before even my learned friend, Queen's Counsel, Mrs. Hay, came into the matter, they embarked on the poker without appreciating the subtle nuances between the Money Laundering Act, its repeal, and the effect of poker. After all, it was early in the days, 2013, still just 6 years after the Proceeds of Crime Act would have been enacted, not subject to a lot of discourse, a lot of litigation, still early days yet. And I think as they have gone along, they have realized that, perhaps we could or should have done this differently. But it's, as the song says, it's too late to turn back now.
Could I ask you just...
Yes, my lord.
You referred to the appellant's paragraph 30 of the statement of case.
Yes.
And I understood you to be agreeing with everything that was contained in that paragraph.
No, I said insofar as, my lord.
So what do you agree with and what do you disagree with?
I said, I agree only with the part where it says there appears to be no statement of legal principle that background information must be evidence of criminal acts. That is what I agree with. Okay. Nothing else.
Okay. Thank you.
Yes, much obliged. And I emphasize that point because I'm saying the Court of Appeal never said that. And if the Court of Appeal had said that, then my learned friends might. Whether they would have been right or wrong is a different matter, but they might have had more of a chance of arguing that successfully, in my humble view. So I'm not going to, I refer to the Assets Recovery Agency case again in paragraph 48. I won't return there. I will move in the interest of time to paragraph, and I know I'm still not going to be penalized for slow overboarding rate, but I refer next at paragraph 49 to the matter Louis Smith against the Director of Public Prosecutions and another. That's a case from the Jamaica Full Court, my lords, 2021, a very recent case. Full Court decision at page 3, and it can be found electronic bundle 0812. 0812, my lords. And in Louis Smith, the court had to analyze, among other things, poker and the said section 25 with which your lordships engaged my learned friend, Mr. Williams. And the court stated unanimously at paragraph 80 of its decision, and paragraph 80 of that judgment, my lords, can be found at 0841. And I will seek your Lordship's permission just to read it very quickly. Paragraph 8, it says, "It is our considered view that when Justice Wolf-Rees came to the conclusion that the applicant was rightly charged for the offences committed prior to May 30, 2007 under the Money Laundering Act, she was not off the mark, as has been suggested by Mr. Wildman, but rather she got it right when she said at paragraph 44 of the judgment, and I quote, 'It is my considered conclusion that the applicant was rightly charged for the offences allegedly committed prior to May 30, 2007 under the Money Laundering Act, that by virtue of Section 25, subsection 2 of the Interpretation Act, 1968, it is clear that where no contrary intention is shown by the new legislation, the rights, liabilities, obligations remain and may be instituted, continued, or enforced as if the repealing act had not been passed. Based on the foregoing of the view that, applicant has not satisfied the required test that he has an arguable ground or a realistic prospect of success.' So this is where full court was throwing out an application for judicial review, my lords, and the court recognized, which I don't think is in dispute, but I just wanted ex abundante cautela to say before your lordships that the Interpretation Act, which can be found at tab 230616 of the electronic bundle, so the Interpretation Act is at 0616, and section 25 subsection 2, which has captured our imagination here, is at 0632, my lord. So I won't dwell on that. At paragraph 50 of our submissions, I mentioned a Court of Appeal judgment of Warren Castle, which I was frank with this court to say that that judgment was actually overturned on appeal to this honorable board. But it highlighted a similar situation here, where the Court of Appeal heard an appeal from the Montserrat High Court and held that a money laundering conviction secured under the Montserrat Ration Proceeds of Crime Act 2010 for crimes committed in 2007 should be quashed and a new trial be held under the applicable act, which was the Repeal Proceeds of Crime Act 1999. So it had a similar legal construct like Jamaica's statute. But the appeal there was allowed for different reasons, and I mentioned that at paragraph 51. We don't need to belabor that point, if it pleases you. I move next to cite to your lordships that also instructive on this point is a decision of the House of Lords. Waddington against Meyer, reported at 1974, volume 2 of the All England Reports at page 377. And this is a decision of the House of Lords which ruled that the penal provision of the Immigration Act 1971, they were not retrospective, and therefore a person could not be convicted of any offense under that act regarding anything done by him before the act was operational. And Lord Reed, let's remember, delivered the unanimous judgment of what I call a powerful panel of that court. And I had two extracts from the case. I don't need to read those, my lord. Those are quoted just as part of paragraph 52 of my submissions. I don't need to delay this court with reading those. I move to paragraph 53 of my submissions. And my submissions, my lord, in paragraph 53, we say, amazingly, the appellant closes her submissions on this very first question which we have been analyzing by essentially indicating in paragraph 32 of her written case likely or possible difficulty in proving the offences against the respondents at the said part of her trial if not allowed to utilize the background evidence under POCA. Now I pause here, my lords, because firstly, we do not know what this background evidence is. We don't even know if it's even going to be relevant. So how can you even say to this honorable board that there will be likely or possible difficulty in proving the offenses against the respondents? How can you say that? So that is, and I'm saying specifically in relation to the unsealed material. So let's say there is material already before the court, including the 9 certificates of title to which I referred, which predated POCA. Court of Appeal decision is clear. This board decision is clear. You can't use that to convict on a poker. What has happened is the appellant, the prosecution, they went astray. They went under the wrong statute. They went under the wrong statute, and they're reaping the consequences of that error. And they're trying to get this court to patched up, not just put on a Band-Aid, but to do corrective surgery and everything, and it should not be allowed, my lords.
I don't understand that point, because I mean, they've gone under POCA. The
Yes,
prosecutions are under POCA,
Yes.
and nothing we decide can change that.
Indeed, my lord.
All we're concerned with is the legality of the investigation insofar as it relates to material dating prior to 30th of May,
Indeed.
2007. Yes.
Indeed, my lord Hodge. But the point I'm making is what this court, what my learned friends want this court to do is to say the Court of Appeal was wrong. And therefore, we can use, depending on what we might find when this material is sifted or unsealed, we can use anything which is pre-30 May 2007, as long as we are calling it background information, which is necessary to prove the charges brought on.
It's all subject to the trial judge's discretion.
Indeed, at the end of the day.
It's not up to them.
At the end of the day, I totally agree with that proposition, my lord. Save and except, I would say this, that all the Court of Appeal has done, it has circumscribed the parameters within which the sifting should take place. That is all I'm saying. The Court of Appeal is not usurping the trial judge's role. That is my humble view. It has usurped, just as your lordships, when you sat as the board back in the assets recovery case in 2015 and rendered your judgment, that no, we cannot look at this material for the purposes of a CIO. We can't look at this once it's pre-30 May 2000. That's all the Court of Appeal has done. It has followed your guidance. So it can't be faulted for that. So I am much obliged to your lordships for those two timely interventions. Much obliged. And if I might continue, so I make the point under paragraph 53 that what they're essentially saying is untenable. And we state that the appellant's difficulty, I'm at paragraph 54, in establishing the criminal charges against respondents should not be a relevant consideration when POCA is pellucid and the permissible and proper route was preserved by Section 25 of the Interpretation Act. I have already made the points at paragraph 55 and 56, so I don't need to stop there. I just move straight into addressing the appellant's second question, and I won't be very long on that. Now, in relation to the second question, your lordships might recall, I set it out verbatim at paragraph 23 of our written submissions. The second question is that a money laundering prosecution background evidence must amount to criminal conduct within the meaning of Section 2 of the Proceeds of Crime Act, etc. Again, Court of Appeal never said that. So the similar submissions I made in relation to the first question, whether the background evidence must amount to a criminal offense, we would commend to this honorable board those submissions as far as that is concerned. And I make the point under paragraph 58 of our submissions and also paragraph 59, that when you look at the material and the appellant submission before the board, it confirms that the reason for seeking to adduce this so-called background evidence is to prove or assist in the proof of criminal charges, including money laundering, against the respondents under POCA. I'm at paragraph 58 of my submissions. At this very part of criminal trial. So they also want to prove that the respondents were guilty of criminal conduct under the Repeal the Money Laundering Act without having charged them under that act, to assist in securing convictions under POCA. That is what this is all about. In other words, I'm at paragraph 59, they want to use events and material which came into existence before May 30, 2007, to prove that the respondents are guilty of offences which, strictly speaking, stricto sensu, they could only have committed them after May 30, 2007, based on the provisions of POCA which we have distilled. That, we are submitting, my lords, is an impermissible way of approaching it. Well, in my submissions, I call it prestidigitation, no offense meant. On the one hand, the appellant pays homage, or my French would say homage, to Section 2 of POCA in word, but violates or attempts to violate the spirit and intent of the legislation. We submit they cannot simultaneously blow hot and cold. They can't run with the hounds and hunt with the hares. They can't approbate, reprobate, quota probo, non-reprobo. They can't. They're trying to, as we say in more common parlance, eat their cake and still have it, or as often said, have their cake and eat it. So, my lords, our submissions deal with that point very, very clearly. And the emphasis on this point which I made, just to assist your lordships, you will see it at paragraph 61 of our submissions, where the Court of Appeal, in its decision refusing leave,
Just going back to paragraph 60.
Yes, my lord.
So you're accepting there the Court of Appeal held any background evidence which is being utilised to prove, buttress or assist in the proof of criminal offences must have occurred after 30th of May.
Essentially.
Yeah.
And
that's the essential issue which the appellants are taking.
Yes, if you to prove criminal offence, there's background evidence and there's background evidence. All animals are equal, but some are more equal than others. So, for example, I might use a simple example, if it pleases you, simple in my respectful view. There's an allegation that my clients, the second and third respondents, are sisters of this chief person, Hamilton. Background evidence could be proof of their birth. What is on their birth certificate? My learned friend, Mr. Williams, referred to public documents. That background evidence would have existed pre-POCA. We couldn't argue if that evidence could be relevant, that they are sisters. That's a simple example. But criminal conduct, that is not criminal conduct. But criminal conduct, which, if you are going to try and adduce evidence, for example, to say we did something prior to the 30th of May.
The reason why the background evidence as to the relationship is relevant is because it goes to the motive for committing a crime after the 30th of May 2007.
Well, respectfully,
if they were totally and utterly unconnected and not friends and didn't know each other, then you would be raising the question as why on earth did they do it? And so,
my lord,
it is evidence prior to 30th of May 2007, which bears on an issue as to whether an offence was committed after 30th of May 2007.
My lord, I would look at it in a different way, respectfully. It is evidence of the consanguinity, potentially, of the parties. It doesn't follow that because I'm your sister or you're my brother. My lord,
of course it doesn't follow. I know where it's going.
Yes.
Just because you're related doesn't mean to say you're going to be committing a crime.
You have preempted me, my lord.
I know.
I won't believe it.
But it perhaps is a factor, a circumstance to be taken into account in making the decision as to whether a crime was committed after the 30th of May 2007.
And my lord, Stevens, I think it is. That is why I proffered that example. I volunteered it for my learned friends. I wasn't hiding from it. I gave it as an example that if you try to adduce that type of evidence of what the birth certificate says to prove we have the same mother, for example, we couldn't really argue with that.
Of course not.
Of course not. Much obliged.
Yeah.
So you see, my lord,
but going back to Lord Hamlin's point, paragraph 60 of your statement of case
yes, my lord,
ties in with paragraph 67 of the statements of facts and issues which you signed. That's the essential point in the appeal.
yes.
The essential issue is whether or not you can investigate background material which occurs prior to 30th May 2007.
Yes. And our humble view, my lords, is that Bearing in mind the guidance from this court in the Assets Recovery Agency case, ex parte Jamaica, if you are going to investigate with a view to try and use that material to convict under POCA, you can't. You simply can't. Because you then would be trying to adduce evidence of criminal conduct. And if that criminal conduct predated May 30, 2007, you have to just forget it. You have to find evidence elsewhere. That is, it's just been delineated that way.
Can I test that? If you look at at electronic bundle 175, this is the affidavit in support of the warrant.
Yes, my lord.
Where it's reported that there's a correlation between the travel patterns of the second respondent
Yes.
To and from the United States and the lodging of money into a bank account. And we see the first three entries occurred on the 19th of April 2007.
Yes, my lord.
Shortly before POCA came into operation.
Yes, my lord.
The order that the Court of Appeal has made that any documents that vouch this cannot be part of the investigation, or they cannot be a recovery from the investigation.
Yes, my lord. And I'm looking at...
On what legal basis is that prima facie relevant background information? Because the case that has been made in this affidavit, as I've read it, is that money was being imported to Jamaica in tranches of less than $50,000 to avoid the declaration of those money to the financial authority, those monies to the financial authorities, and thereafter being invested in properties.
And I would address your lordship's question in two ways. Firstly, all of this is still to be tested. There's a partnered criminal trial.
Oh, yes.
Yes, that's the first point. Second point, my lord, is that this material from, and let me use the example from, say, the return to Ireland, the 19th of April, 2007.
Yes.
This is pre-POCA, 2007. You can investigate what you want, but the law is clear, it's crystal clear. You cannot abuse this material to establish guilt if you are going to use it to try and prove criminal conduct. Because the criminal conduct must have occurred after 30 May 2007. So if there's other material, if there are 10 bits of evidence, and 5 are pre-POCA and 5 are after POCA, you have to go with the 5 after POCA. It might seem strange if you call it that, but the line must be drawn somewhere. It can't be at large, generally speaking. That's what the legislature has said, and that's what this board itself has recognized in January 2015. And that is the guidance the Court of Appeal took, my lord. And my learned friends have not said to you, you need to overrule or seek to overrule your own decision. Mr. Mitchell never went that far because he knew he could not.
Well, let's take a hypothetical case that shortly after 30th of May 2007,
yes, my lord.
Several months later, the second respondent, the second respondent, for example, made money available to first respondent to purchase property.
Yes, my lord.
Are you saying that the fact that that money had come into the country before then, and the bringing of the money in might not of itself be an offence under POCA, would mean that it's completely irrelevant to establish the course of conduct that was being conducted?
You can't do that under POCA. And that is why the Parliament preserved the right. The prosecution, if it feels that money was the source of that money was criminal, you would have to charge the second respondent under the Money Laundering Act, my lords, respectfully. That is all.
Let us say it was relevant to the first respondent's knowledge of what was going on, rather than the first respondent being deemed to have absolutely no knowledge of what was going on until events started on the 1st of June 2007. Let us assume that there was evidence that for some time before that there had been a pattern of behaviour on the part of Mr. Hamilton and his sisters and the first respondent whereby money was brought in from the United States in small tranches and was then used to purchase properties in which the first respondent was carrying on business. Would the existence of that prior behaviour, which would not amount to an offence under POCA, not be relevant as to the state of the first respondent's mind, for example, in the post-1st June world?
My Lord, respectfully, it could not be relevant for two reasons. Firstly, one, well, it wouldn't be admissible because it would have to be relevant for be admissible, and it couldn't be.
You say it couldn't be.
No, I'm saying it. Firstly,
it couldn't be relevant. Why not?
First, that firstly, it wouldn't be admissible because it would not be relevant. It could not be relevant because it fell afoul of Section 2 and also Section 91, 92, and 93 in its definitions of criminal conduct and criminal property. You cannot avoid the parameters of these sections, my Lord, even it might appear that the consequences might seem a little strange, my Lord. That is why the previous statute was preserved. You go under the previous act and you prove your case then. It might mean, my learned friend Mr. Williams touched on it, you might end up somewhere where there might be some lacuna, almost as if you're in purgatory. I don't know, my Lord, there might be this middle ground where, as Mr. Williams, I think, was the one who said it doesn't fall under the Money Laundering Act, it doesn't fall under POCA. Where do we fall? Do we call it mom POCA? I don't know. But you might have, that is something the statute has to address, the Parliament has to address. If we have come across that. Fortunately, I don't think we have had to contend with that yet. But my respectful submission, my Lord, based on the underpinning constitutional provisions and based on this clear wording of the statutes, the questions, my Lord, Hodge, you have asked, it could not be used to inculpate these people with the greatest of respect. I'm much obliged, my Lord. And I'm close to finishing, my Lord, and I would like to close my treatment of the second question, and I'm at the end of my submissions on the second question, which is paragraph 66 of my submissions, which say that the Court of Appeal, fortified by the support of this board's decision in the Assets Recovery Agency ex parte Jamaica case, recognized by its judgment, both in the main judgment and the lead judgment, that the Parliament of Jamaica made it abundantly, eminently clear that criminal conduct prior to May 30, 2007 cannot be prosecuted under POCA. I wanted to just close on that.
I'm not sure if that is disputed.
Yeah, well, I repeated it because it goes to the essence or the atta of what your Lordship was just asking me. But
Edward, you're running out of time, so yes. You better move on to the third question.
Third law, and we're there, my Lord.
2 minutes.
At paragraph 67, this question was not below at the Court of Appeal, and perhaps it's more of something being said consequentially by the appellant. That, and we're saying it's not quite clear, but be that as it may, we're saying that no authorities were cited to support this proposition, and your Lordship would recall that they're saying that the consequence of upholding decision by the Court of Appeal would be denying investigators the right to seek material that might otherwise. We have already shown that that is not so. And hence my example with the birth certificate. And my Lords, we state that the Court of Appeal judgment was quite correct. And in distinguishing the appellant's authorities, at paragraph 72, Petman, R against MT, R against Alan Phillips Charles, R against, my Lord, it's reported as Kevin Young, but that was an error. The case is actually Queen against Kevin Williams. Your Lordship might take due cognizance of that. Myers against Bragman and Anthony against Sawaniok. All these cases, my Lord, not only are they distinguishable on the facts, and my learned friend Mr. Mitchell seems to have been enamored with the Swedish case, R-E-G and W, you know. I think that love might have been unrequited when you look at it deeply. But that case is totally irrelevant, bearing in mind the special legal construct of Jamaica's statute. And that case, the speciality, that case, the extradition, it's special provisions, my lord. That case is totally restricted to its own facts. And that having been said, I conclude, my lord, in saying that the appellant has not demonstrated respectfully that the Court of Appeal of Jamaica was wrong in its rulings and the various statements it made as reflected in its said judgments. What the appellant has done, it has ignored the route provided by the statutes, which is what we say that they could and should have done. So if your lordships were to, for example, dismiss this appeal, which we hope you will do, there is still a route open. They're not left without relief, my lord, as they would have you believe, my lord. And my lord, it is our respectful view that is the position. And before I... The issue of whether the background question is not whether it would be helpful, but whether incomprehensible without, but be that as it may, my lord. Before I forget, I just want to say I join in my learned friend, Mr. Williams' submissions in relation to the Delahaye against A. Mauritius Limited case, which is a judgment of this honorable board. Lord Hughes again delivering the judgment of this court, 2018. My lord, we humbly submit that this appeal is bound to fail, and we ask you to rule in that respect. Unless I can be of any further assistance to your lordships, my lord, those are my submissions.
Thank you very much.
Much obliged, my lord.
Mr. Mitchell.
Well, can I pick up some headline points from my learned friend's submissions? Mr. Williams is still wedded to the immediate admissibility point, as he seeks to argue that relevant evidence, which is a feature of the two pieces of legislation which were considered in the English authorities, must be somehow read into the Proceeds of Crime Act in Jamaica when it comes to investigations. It isn't there. It's not part of the scheme. Your lordships will be looking to the issues of public interest, substantial value to the investigation. And therefore, the immediate admissibility point, in our respects, submission fails. And so his reliance on Ex parte Hill and the Derby Magistrates case don't assist. The second point that the learned friend took was this public interest point, the right to privacy and the constitutional rights that flow. Lord, part of his argument was that counsel wasn't representing the first respondent, and she was, and I quote him, forced without counsel into doing her best. For your lordship's notes, she was represented by Queen's Counsel at the application for permission to unseal the documents. That counsel then filed notice and grounds of appeal, electronic bundle 195. Counsel then settled, and having amended those grounds of appeal, electronic bundle 197 to 199.
What was the first number?
Electronic bundle 195.
195. Yeah.
So that's settled by leading counsel. The amended grounds settled by leading counsel 197 to 199. One of Mr. Wilkinson's skeleton arguments picks up, and if I may borrow a move to an analogy with cricket, runs, maybe perhaps more athletics, runs with the arguments within the two settled grounds to which I've referred in his skeleton argument, which is between pages 215 and 225. It was therefore not clear, my learned friend having said it was shortage of funds, why, having had leading counsel through Mrs. Justice Straw's application, then to settle and amend the grounds of appeal, the first respondent decided not to be represented at the appeal, but she opened the appeal and represented herself. And then Mr. Wilkinson did go into bat. And he batted for the respondents because his skeleton very much followed the grounds of appeal, and that is pages 215, as I say, to 225. It therefore follows that when the Court of Appeal at paragraph 115, I seem to recall, and I'll be reminded of the electronic bundle page, summarise that the constitutional argument was not vigorously advanced. Your Lordships will look at that in the context of the arguments that were before them, including those put by my learned friend Mr. Wilkinson, and that paragraph is at the electronic bundle, page 290. My learned friend, third point, Mr. Williams, goes on to erect an argument around the warrant access conditions. Of course, Lord, if that begins to be an argument that has any legs, that has absolutely nothing to do with the 30th of May and has all to do with whether or not the warrant itself should be struck down. And that's been not only the subject of separate litigation in which I think the Court of Appeal have said that the warrant was properly granted, but is not the subject of any litigation of the branch that has led to the issues that come before your Lordships on this appeal. But where he says no public interest, would your Lordships please note electronic bundle 158, sorry, I should do it in order, 154 and 158, where the affiant and the appellant refers to issues connected with the DEA, the FBI, and the relationship of events in the United States and the cross-border, therefore, issues that arise, and we would submit the public interest is clear from that. He then says there's no investigation under POCA. Please note electronic bundles 155, paragraph 18 of the affidavit, where the affiant refers to that, and the use by her of language which is only consistent with POCA and no other legislation, paragraph 42, page 171. My learned friend then says, well, there's no discussion about a disclosure order as being inappropriate. I've used the expression eye-watering. My Lord Hodge has said that he's had an opportunity to at least skim, I think, the affidavit of the appellant. If I was to say that anybody reading that would be able to infer that the first respondent might wish to impede the investigation, would I be far removed from establishing that principle? And your Lordships will remember from the case of ex parte Lewis, if we could just go, please, to page 1072. I hope I've got that correct. Let's take my Lord there. This is the ex parte Hill case. And Lord, at 1072, I think the paragraph that I would like to, the part I'd like to highlight is here, Lords. It's about perhaps a third of the way in, quarter of the way in, towards the end of the line. Does your Lordship, did my Lord see the highlighted blue Court of Appeal in Barclay's reference, and then go down 3 lines to the end? Even though an accused person such as the applicant has no statutory right to be given notice or to be heard, it may sometimes be that in a situation of this kind, the judge to whom application is made may think it helpful to hear what such a person might wish to say before he decides whether to make an order or not. That would not be an appropriate course where notice to the defendant might impede the process of investigation, but might be appropriate in a case like this where no conduct by the defendant would be at all likely to affect the availability of the bank records. Whether to adopt this course would, in any case, be very much a matter for judge's judgment. It would not be something he could be compelled to do, but something he might find helpful. So far as this argument is concerned, I'd hold the learned judge was entitled to make the orders that he did, without notice the applicant, remember this was to third parties, and that he was right not to set aside the orders on this ground. What we take away from that is that it's perfectly clear that if a suspect is the subject or target of a search warrant, that the reference to the need to satisfy oneself that a disclosure order would be more appropriate is probably speaking for itself just by looking at the facts. That then takes us to a fourth point that he made, and this is his argument about money laundering and Mr. Wilkinson's reference to the money laundering cusp. Lords, whether or not the events before the 30th of May are capable of being criminalised is not the test. The test is, as my Lord Hodge indicated to one of the learned friends during submissions, is whether it's relevant to the charges that have been brought, the charges on or after the 30th of May. And if the evidence, like the birth certificate to which Mr. Wilkinson referred, establishes a link that is of that kind of importance between the various defendants in a money laundering case alleged on or after the 30th of May, then that material is relevant, whether it be criminal or not. And that is why, picking up on my learned friend Mr. Wilkinson's submissions, our questions were posed the way they were. The Court of Appeal, we submit, appear to be saying, because of the line they drew in the sand for the 30th of May, that if there's conduct before the 30th of May, it can't have been criminal, therefore it can't be admissible in the trial. And we submit that's wrong. We submit it doesn't have to be criminal. It could be, because of the Money Laundering Act, but it doesn't have to be criminal. It has to be material which will assist the investigator in the public interest by being of substantial value, either on its own or taken together with other material. That's the test. And in our respectful submission, particularly where you have, as one of the defendants in the criminal trial, an attorney in a very long-term transactional relationship with a convicted drug trafficker and his family, that relationship and the proof of that relationship becomes important. Curiously, on the issue of repeal, Section 140, which repeals the Money Laundering Act, is not in government prints of the legislation. It stops at Section 138 and follows with the word schedules. And indeed, my own friend brought with her a government-supplied proceeds of crime book, which only goes to Section 138. There is no doubt that in some prints of the law there is a Section 140 which repeals the Money Laundering Act. The question is whether that happened on the 30th, with effect from the 30th of May, or was added later. We don't know, but in our respectful submission, it doesn't matter, for the reasons that I have said.
You're prepared to assume that the Money Laundering Act
I'm prepared to assume it was repealed with effect from the 30th of May. If I find out, Lord, very soon, that there is a subsequent amending piece of legislation, of course I'll put it before the board, but I'm prepared to assume that that is the position.
If you are able to track down the elusive Section 140, I think we'd like to see it.
Yeah, I'm sure, and I absolutely agree. And in fact, the Lordships will have noted, if you go, please, to electronic bundle 665, but go to the last page, 670, that it stops at 138 regulations and then schedules. and that's the one with the legal notice reference at the bottom.
Yes, I went through the index looking for a section called repeals, and I didn't find it.
No, you didn't. And so we will bottom that out, and we'll circulate it to learned friends. Much of what Mr. Wilkinson has said, if you strip out references to cricket, literature, and chess, comes down to this. You can prove material that is relevant to criminal proceedings that predate the charges, but you can't if it's under POCA. And we submit that that is a flawed submission. Unless I can assist you further, Lords, those are the replies on behalf of the appellant. It's 4 o'clock.
Thank you very much.
Pleasure.
The board is very grateful to counsel for their assistance in presenting their clients' cases in this appeal. And the board is also very grateful to those who assisted counsel in presenting the papers and the written arguments. The board will take time to consider what advice they will humbly tender to Her Majesty.
Thank you.